rehabilitation of torture and trauma survivors, and the diplomacy training program. The diplomacy training program is based at the Faculty of Law and Justice at the University of New South Wales in Sydney, and is on the land of the Bidjigal people of the Eora Nation. And I pay my respects to their elders past and present, acknowledge that we're on their country, that country has never been ceded, and that the struggle for recognition of rights and for justice continues today. And so we acknowledge and welcome any elders we have from the community, past and present. It's a pleasure to welcome you all here. The Diplomacy Training Program is a small non-governmental organisation established by the Nobel Peace Laureate and current President of Timor-Leste, President José Ramos Horta. We were established to build the knowledge, skills and networks of human rights defenders across the Asia-Pacific region. This webinar, it's an important webinar focused on building knowledge and understanding of genocide and of the Genocide Convention, flows from a partnership with STARTS, New South Wales-based organisation focused on working with and supporting the survivors of torture and trauma, refugees and migrants who have come to Australia from many different countries. We have a partnership with them focused on capacity building of community leaders, so to enable them to understand international human rights law, to understand Australia's obligations to human rights, and to more effectively engage in human rights advocacy. We have held 2 face-to-face workshops now with STARTS and 30 plus community members. They have come to us to ask us to put on a series of webinars focused on different international law issues. And this series on genocide and the Genocide Convention is the first of these series of webinars. The purpose of this webinar is really to build an understanding of the international law relating to genocide, and also how advocates can use their understanding of the international law and government obligations under the convention in their advocacy strategies. So this is the first of 3 intended webinars on the Genocide Convention. In this webinar, we would like to focus on the development of the concept of genocide, the development of the legal standards on genocide, in particular, the development of the convention over 75 years ago, following the end of the Second World War. We will have a focus on 2 case studies in relation to the convention, Myanmar and Israel, Palestine. The discussion will be led by 2 very esteemed international experts, Professor Chris Sidoti and Francesca Albanese. Chris will lead as a background on the development of the law and the concepts, and also have a look and a focus on Myanmar based on his extensive work there. And Francesca will then follow and will have a particular focus on the situation in Palestine. So the webinar will be recorded. We will ask Chris to speak first, and he will be followed by Francesca. And then we will hope to make sure that there is sufficient time for questions and for discussion. And we ask that that's done in the spirit of human rights and respecting everyone's dignity, and that we can have a very good and productive discussion. My colleagues now and Claire will be helping to moderate, to share links and to manage the discussion. And as I said, I think the webinar will be recorded, and we hope to be able to share resources and PowerPoints arising from this. If you have questions as people are speaking, please put them in the chat, and we will come to them at the end. Also, if you have any issues you want to raise, please share them in the chat, but the chat won't be public at this stage. I think our preference is, if your internet connection allows, that you have your screen on, because it's really helpful for our speakers who are donating their time to us today to see who they're speaking to, and it's much nicer to speak to a face than just a blank screen. So if you can put your screen on, that would be really appreciated. I think that's it from me, other than just to say some further words of introduction for Chris at this stage. So Chris Sidoti is an international human rights expert. He's currently a member of the UN's International Commission of Inquiry on the Occupied Palestinian Territory. He is also a founding member of the Special Advisory Council for Myanmar, along with Marzuki Durisman from Indonesia, with whom he served as a member of the UN Independent International Fact-Finding Mission on Myanmar, which released 3 reports across 2018 and 2019, exposing widespread human rights violations, including systematic gender-based and sexual violence by the Myanmar military against ethnic minorities, particularly the Rohingya, and the military's business interests and involvement in human rights violations. From 1999 to 2013, Chris led a human rights initiative between Australia and Myanmar, trying to build support for human rights as part of the transition away from military rule to an inclusive democracy. Chris has held a number of prominent public offices in Australia in the field of human rights, including at the Australian Human Rights Commission, where he was commissioner from 1995 to 2000, playing a significant role in its inquiry into the stolen generations, the removal of Indigenous First Nations children from their families, which came to a finding of genocide in relation to Australia. So, Chris, we could barely have somebody more qualified to speak and introduce the issues for us. Thank you very much for joining us this morning. I pass the floor to you. Chris, you're on mute, I think.
It's okay. It's been released, I think. Thank you very much, Patrick, and good evening to everyone in Australia. Good afternoon, good morning to those in Europe and Africa. A special greeting to my friend and colleague, Francesca, who will be speaking after me. As Patrick indicated, I'd like first to introduce the international law that is relevant to the situation of genocide, and then speak a little about the case of Myanmar and the Rohingya people. So I hope that by introducing the law first, although it will be a fairly technical introduction, it may provide the context in which we can look at the Myanmar situation, and then after me, Francesca can look at the situation of Palestine and Israel. So first, the law. Next, please, Norm. There are 4 categories of international crime relevant to war and peace. Those categories are crimes against humanity, war crimes, genocide, and the crime of aggression. The crime of aggression is the most recently defined, but the first 3 have their origin in the decisions of the Nuremberg Tribunal after World War II, and then decisions taken by the Yugoslavia Tribunal and the Rwanda Tribunal during the course of the 1990s and early 2000s. These crimes are crimes found in international customary law, but they are defined in accordance with customary law in the Rome Statute of the International Criminal Court. There is no hierarchy amongst these crimes. Although often you will see reference to genocide as the crime of crimes, that in fact does not reflect what international law says. There is no hierarchy. These are all extremely serious categories of crime. Collectively, they would be called crimes relating to atrocities, mass atrocities, and each is very significant in its own right. So sometimes there's a popular discussion that unless genocide is found, there is no serious crime. That's not the case. War crimes and crimes against humanity are also serious crimes. Thanks, Norm. Crimes against humanity are any of the acts that are listed there, I'm not going to read them, that are committed as part of a widespread or systematic attack against a civilian population. Each of those stands alone. That is, that each of them can individually constitute a crime against humanity. The definition is important in relation to the widespread or systematic attack and in relation to it being against a civilian population. Individual acts don't constitute a crime against humanity unless it is part of a widespread or systematic attack. And that component always needs to be considered in deciding whether the facts support an allegation of crime against humanity. The second category, Norm, is war crimes. War crimes are those actions that constitute grave breaches of the Geneva Conventions. The Geneva Conventions collectively constitute the law of war. And so war crimes arise in relation to international armed conflict, although their scope has been extended to cover non-international armed conflicts as well. So to take the obvious example of Myanmar, Myanmar is not an international armed conflict, but it certainly meets the standard of non-international armed conflict. And so the Geneva Conventions apply, and war crimes can be committed in the context of the conflict in Myanmar. Now, genocide. Genocide is the most difficult crime under international law to establish. The definition, and there you see the extract from the Genocide Convention itself and from the Rome Statute, which takes into it the definition of genocide under the convention. Genocide has a number of component parts in law. Let me first refer to the list A to E. These are referred to as acts constituting genocide. One of these categories of act is necessary if the crime is to be constituted. Killing members of a protected group, causing serious bodily or mental harm to members of a protected group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the protected group, and forcibly transferring children of that group to another group. Now, these four categories of crime are, it is not necessary to prove all of the five to constitute the crime of genocide. Any one is sufficient. It's important then to recognise the popular misunderstandings about the crime of genocide, and there are many. The legal understanding and definition of genocide is very different from what popular understandings may be. And that's evident in relation to A, killing members of the group. The crime of genocide does not require mass killings. In fact, the crime of genocide can be constituted without a single person having been killed, provided that one of the other five categories is established. Then it's possible to establish genocide, even without establishing that members of the group have been killed, either in large numbers or indeed at all. Patrick referred to the fact that some years ago, back in the late 1990s, I was part of an Australian Human Rights Commission inquiry into the removal of Indigenous children from their families. Now, in that case, after a great deal of fact-finding and legal analysis, we came to the conclusion that genocide had been established. And it was established because of category E, forcibly transferring children of the group to another group, the removal of Indigenous children, therefore constituting genocide. Now, in that example, we did not find any killing at all. Certainly, there were killing of Indigenous people in Australia in large numbers in the 1800s. But in the case that we were examining, the removal of children, we did not find killing of members of the group, but we did find forcible transfer. In that instance, our finding of genocide was roundly condemned in the Australian media and in Australian political circles because Australians were simply not prepared to accept that genocide occurred in this country. Yet, applying the legal definition, we established it. So firstly, we have those 5 categories of act. Second, it's necessary to establish an intention to have committed one of those 5 categories of act. That's the first intent. And in that respect, genocide is not much different from war crimes or crimes against humanity. There must be established in each of those cases as well an intention to commit the acts in question. Genocide, however, has a second intent called genocidal purpose. And this is where the difficulty arises in proving genocide. It's necessary to establish that one of the acts was committed with the intent to destroy in whole or in part a protected group. And protected group is defined under 4 categories: national, ethnical, racial, or religious. Ethnical is a strange word. I've not seen it used in any other legal document or in common usage. I guess we can say that it means what we mean by the word ethnic. So the group must be defined in terms of its national, ethnic, racial, or religious characteristics. These 4 categories are important. Note in particular that political is not amongst the categories. And so the destruction of a group in whole or in part for political reasons, because of their political beliefs or status, cannot constitute the crime of genocide. Perhaps the most extreme example of where that distinction is relevant relates to the mass killings committed by the Khmer Rouge in Cambodia in the late 1970s. There were literally millions of Cambodians killed during the period from 1975 to 1979. But only some of those killings have been held to constitute genocide. And that is where the killings were committed against Cambodian ethnic minorities, and those people were singled out on the basis of their ethnicity. The mass killings of millions of Cambodians for political reasons did not constitute the crime of genocide, because genocide does not extend protection to a political group, only to groups defined by nationality, ethnicity, race, or religion. Now let me go back to that genocidal purpose, the second intent, to destroy the group in whole or in part. It's very difficult to establish genocidal intent. It's very easy. The evidence is always available to say that there is an intention to commit the acts, an intention to kill, or an intention to take away, to remove the conditions necessary to sustain life, or the intention to remove children. But to demonstrate, to prove that this is done for the purpose of destroying the group in whole or in part is the most difficult part of establishing the crime of genocide. Sometimes there is a smoking gun. There are clear statements of this genocidal intent. And I'm sure that Francesca will refer to this element in discussing the situation in Palestine and Israel. But it's not often, and sorry, I should also say, that was the case in relation to the removal of children in Australia. We had clear statements of policy dating from the 1930s, where it was said that the removal of the children was designed to facilitate the destruction or the elimination of Indigenous people in Australia as a group. Clear statements of policy. But in most instances, those that are carrying out the acts do not make a clear statement of intent to destroy the group in whole or in part. Mostly, that has to be established by inference using circumstantial evidence. That is, using the facts and inferring the intent from the facts. The challenge there is that international criminal tribunals that have considered the situation of genocide have said that it's necessary to prove that genocide is the only purpose, the only reasonable purpose for the commission of the acts. And that's a very high standard to meet. Not that genocide, that is the destruction of the group, is one of the purposes or even the predominant purpose, but the sole reasonable purpose for the commission of the acts. So in the absence of clearly stated intention, clear statements of policy, the use of circumstantial evidence to establish genocidal purpose is a big challenge in these court cases. So listed there in the overhead are the elements of genocide that has to be established. One of the 5 specified categories of act, committed against a group defined by nationality, ethnicity, race, or religion. Proof of intent to commit one of those 5 categories of act. And the fact that they are committed with the intent to destroy the group in whole or in part. In relation to in part, I should indicate that the part can be determined geographically. It may be possible to establish genocide by saying that the genocidal effect, the genocidal intent, relates to a particular geographical area and not to the entire planet. And so seeking to destroy a group defined by nationality, ethnicity, race, or religion in a particular country or a particular part of the country can be sufficient to establish genocide. Let me now turn from the law to the situation of the Rohingya in Myanmar. Here we're looking at the treatment of a group within a particular geographical area. The Rohingya people in Rakhine State, a part of Myanmar. Rakhine State is in the southwestern corner of Myanmar and was part of the ancient kingdom of Arakan. It's an area of Myanmar, like most parts of Myanmar, that has very many ethnic groups. There is a majority group, the Rakhine, and a number of significant minority groups. The Rohingya people are one minority group within Rakhine State, but only one of many. They're concentrated in the northern part of Rakhine State, close to the border of Bangladesh. There is a long history of the various ethnic groups in Rakhine State living together in peace and pursuing both their separate identities as ethnic and in some cases religious minorities, but also seeking prosperity as part of a broader community. The conflict between ethnic groups in Rakhine State has flared from time to time historically, but particularly since 2012 in relation to the Rohingya people. The Rohingya suffered progressively strict discrimination since 2000, with laws and practices being introduced by the national military government, the military regime in Myanmar, excluding them progressively from various areas of employment, freedom of movement, and education. In education, for example, Rohingya people were first excluded from certain faculties at universities, and then progressively excluded from more and more faculties until they were excluded from university in general. Their access to secondary education was gradually restricted, so that increasingly Rohingya children were not able to obtain education beyond primary level. And even their primary education was discriminatory in that it was not at the same standard as non-Rohingya education. From 2012, there have been instances of widespread violence against the Rohingya people. This in the beginning was called by the regime intercommunal violence. It was portrayed as violence against the Rohingya by Rakhine majority people, or violence between Rohingya and Rakhine communities. In fact, when we at the Myanmar fact-finding mission examined the situation in 2012, the conclusion that we came to was that the military was behind this violence and had deliberately orchestrated the violence and then had presented it as intercommunal violence rather than violence committed by and at the instigation of the military against the Rohingya minority. In 2015, much of the discrimination against the Rohingya people was enacted legally in 4 laws passed by the National Parliament before the 2015 elections. These are collectively called the Laws for the Protection of Race and Religion, and they institutionalised discrimination, particularly against the Rohingya, but also other ethnic minorities in Myanmar at the national level. The situation deteriorated greatly in 2016, in October, when 9 police were killed as a result of attacks under the name of the Arakan Rohingya Salvation Army, although it's fairly difficult to understand what that army was, against a couple of police posts. There had been forced expulsions of Rohingya people to Bangladesh, just across the border, since the 1990s. But those expulsions accelerated in October and November 2016, and then even more so in and following August 2017. In August 2017, ARSA launched a wave of simultaneous attacks against 30 police posts and 1 military camp, resulting in 12 security personnel being killed. The response to that was what the military called a clearance operation. Our fact-finding mission found that it led to the deaths of at least 10,000 people, the destruction of 37,000 Rohingya homes and structures, the destruction of 392 villages, and the mass exodus of around 800,000 people. The military constantly referred to this as a clearance operation. There were no policy statements to state explicitly that this was intended to cause the destruction of the Rohingya people in whole or in part as a group. But the effect was to clear large numbers of Rohingya people from the northern part of Rakhine State, 800,000 people. And at the time and since, it has been alleged that these actions constituted genocide. The difficulty, of course, is proving that genocidal intent. Since 2018, the Rohingya people have been scattered. There are 1 million in Bangladesh, there are tens of thousands in other countries, and there are 650,000 still in Rakhine State. Of those who are in Rakhine State, most live in some form of confinement. Perhaps 250,000 live in camps that are essentially concentration camps. They're unable to leave. Some live in a ghetto within Sittwe city, the capital of Rakhine State. Others live in villages where their freedom of movement is restricted and they have difficulty in leaving those villages. So essentially, now there are more Rohingya in Bangladesh than there are in Myanmar, and those who remain in Myanmar living circumstances that can only be called persecution, which is a crime against humanity. The suffering of those within northern Rakhine State has not ceased. Indeed, it's worse now than it's been at any time since 2017. There is fighting in Rakhine State between the military and the Arakan army. The Arakan army is largely a Rakhine army seeking to ensure autonomy for the Rakhine people in the area that was formerly the Kingdom of Arakan. That fighting has waged on and off since 2019. There have been periods of informal ceasefire and periods of intense conflict, but it's been particularly intense since last October, and the military is losing. The military is losing in Rakhine State, just as it is losing throughout Myanmar. Now, most of Rakhine State in the north and the centre is controlled by the Arakan army. There was significant conflict in May in the town of Buthidaung and in August in the town of Mongdo. In both of these instances, large numbers of Rohingya people were killed and many fled, attempting again to escape into Bangladesh, but on this occasion, not being so willingly admitted by the Bangladeshi authorities. It's difficult to know what the goals of the Arakan army are in the current conflict. The Arakan army's leadership has said that they look to an autonomous Arakan, an autonomous area that includes respect for all of the Arakanese minorities. That includes, they say, the Rohingya people, whom they call Rakhine Muslims. But it's not clear whether, in fact, that is being respected by the Arakan army. Certainly, Rohingya people are being killed. Many are fleeing the conflict or attempting to do so by getting into Bangladesh. But whether the Arakan army, in fact, will protect them within Rakhine State is an open question. There have been serious allegations of killings by elements of the Arakan army, which their leadership denies. The military, as always, is discriminating against Rohingya people, and its attitude towards Rohingya people continues. In this situation, and in dealing generally with the crime of genocide, international accountability is a very difficult matter. I want to refer only briefly to this. I don't want to take too much of Francesca's time. International criminal accountability for genocide is possible in two different areas at the moment. One is in the International Criminal Court, and the second is in the International Court of Justice. The International Criminal Court is the standing court dealing with international criminal accountability. It deals with individuals, not states. The International Criminal Court is looking at the question of possible genocide against the Rohingya people, and it is doing so because Bangladesh is a party to the Rome Statute, which gives the International Criminal Court jurisdiction. Myanmar is not a party, and so the International Criminal Court cannot deal with the situation in Myanmar as a whole. Only if there is a reference made by the Security Council or if there is an ad hoc tribunal established for that purpose. So the jurisdiction of the International Criminal Court is limited, and it's restricted at the moment to the forced deportation of Rohingya people to Bangladesh in 2017-2018. The International Court of Justice, however, you might jump to, if you wouldn't mind, Nong, and the next one. The International Court of Justice is also able to deal with the question of genocide. It does not exercise criminal accountability, however. It deals with genocide as a matter of a conflict between states. And so at this stage, the International Criminal Court has a case. Gambia has brought a case against Myanmar under the Genocide Convention, and that case is proceeding slowly through the International Court of Justice. It does indicate that genocide can be dealt with in two forums: criminally, relating to individuals through the International Criminal Court, and as a state-to-state matter under the Genocide Convention in the International Court of Justice. Both of these avenues are being used in relation to the situation of the Rohingya, and as Francesca will indicate, both are being used in relation to Israel and Palestine. I should stop there and allow Francesca to speak, and I'll happily come back to deal with any of these issues or matters I haven't covered during the course of the question and answer session. Thank you.
Thank you very much, Chris. Thank you very much, Chris. That was tremendously clear, both in exposition of the general law and its development, and also then the situation in Myanmar. And also very powerful, I think, mind that these issues are not about the past, but they're very much with us. And maybe I can just acknowledge the very important role that you have played in the critical issues around bearing witness, of documentation, of hearing and gathering the evidence that may allow accountability to come at some stage, even if it is too long a wait for so many. Let me now please introduce our second very distinguished speaker for today's webinar, Francesca Albanese, who is currently serving as the United Nations Special Rapporteur on the Palestinian territories occupied since 1967. Francesca previously worked for over a decade with the UN's Office of the High Commissioner for Human Rights and for the UN's Relief and Work Agency for Palestinian Refugees. She's an affiliate scholar at the Institute for the Study of International Migration at Georgetown University in America, and a senior advisor on migration and forced displacement for the think tank Arab Renaissance for Democracy and Development, where she co-founded the Global Network on the Question of Palestine, a coalition of renowned professional scholars engaged in and on Israel and Palestine. She has, over many years, advised the UN, governments and civil society across the Middle East, North Africa and the Asia Pacific on the enforcement of human rights norms, especially for vulnerable and marginalized groups, including refugees and migrants. Francesca, thank you very much indeed for joining us today. We're really honored to have you here. And I think you will focus in particular on a second case study of Israel and Palestine. So I pass the floor over to you. Thank you.
Yes, thank you very much, Patrick. Also, let me start with some acknowledgement and words of gratitude. Of course, I want to thank the NSW University and for organizing this incredible event. I'm happy to share this virtual floor with my friend, colleague, and mentor, Chris Sidoti, from whom I always learn a lot. So it's a pleasure to listen to you, Chris, and I love the fact that you still stick to PowerPoint. I will not have a PowerPoint. But also I want to acknowledge the Bengal people of the Iora nation and pay tribute to the elders past, present, and future. I'm so glad, and I will always be grateful to the Australian people, both indigenous and settlers, for teaching me the good manners of acknowledging the owner of the land when getting into a country, physically or virtually. And this is something that I will keep on carrying with me. I will definitely be happy, if I can use this term, to share my considerations on how genocide as a legal argument is relevant to capture what's happening in the context of Palestine. And I will try to adapt what I wanted to say to what Chris has presented, both in terms of legal analysis and in terms of understanding of the So first of all, Chris started by saying that genocide is a very difficult crime to prove. Yes, indeed. It is a very insidious crime. And I don't think it's just because of how difficult it is to prove a direct intent, but also for its complexity. It's very difficult to ensure accountability for a crime as complex as genocide, which is it's a collective crime. This is not something that that can be realized by one person only. Technically, theoretically it could, but this has not been the case. To destroy a group in whole or in part requires a plurality of acts in order not to be also this crime confused with a crime of extermination. There is a huge sense of overlapping with extermination, which is also the intentional destruction of space or people. Really, it's a crime against humanity, and it's very relevant. So many of those who critique nowadays the genocide framework as applicable to what Israel is doing say it is extermination. I mean, we are not saying that Israel is not committing crimes, but it's not genocide. The genocide is something else. So let's see what something else is. Because I'm not saying that Israel is not committing acts of extermination or starvation or murder and willful killing and wanton destruction, of course. And in fact, as the international jurisprudence that Chris has referred to point out, genocide as part of its composite nature incorporates other crimes. A fact and a conduct, an act, can constitute both a war crime and genocide, both a crime against humanity and genocide. So genocide is insidious because of how, in order to ensure accountability, we reconstruct a framework that capture what has been done on the ground, and at least in addition to this, the intent, that special intent to destroy behind given acts or one act of genocide, destroy the group in whole or in part. And this is why I think that today Palestine is somewhat tragically pivotal to get a better understanding of what genocide is. And I have to admit that I'm frustrated and a bit annoyed with those, including respectable scholars, who don't even take into account factual and historical arguments and dismiss the claim of genocide on the ground that it doesn't correspond to what the jurisprudence has said. Well, let's look at the jurisprudence. The genocide jurisprudence compared to other crimes is pretty scant. And I would say, thankfully, it means that genocide is not that common nowadays. But at the same time, is not that uncommon. And the understanding genocide in the case of Palestine, where, again, I concluded in March that I found reasonable grounds to believe that acts of genocide had been committed. And after an additional 5-6 months, not only I'm convinced that that assessment of mine in March was accurate, but also over the past 6 months, I have continued to collect facts and conduct legal analysis that corroborate my earlier conclusions. So, in order to understand what genocide is, one needs to use a lens that is, first of all, empty of biases as much as possible, but also take a bit of a distance from what has been established, only to return to it, but what has been established by the jurisprudence. Understand the context in which the term genocide was coined, the crime was codified, why the Genocide Convention was written the way it was written. And then we go to the jurisprudence, because I don't think that the jurisprudence is restrictive. I think that the jurisprudence has elaborated criteria, has further developed the meaning of the law, but based on the specificity of the facts brought before each court. Criminal Tribunal of Rwanda, Criminal Tribunal for former Yugoslavia, and then the ICJ, just to verify, to establish whether, in addition, the extent to which there was state responsibility. So the term genocide, and in a way this complements what Chris has said. The term genocide was coined by a Polish lawyer of Jewish descent in the aftermath of the Holocaust, but in fact he started thinking of it while during the 40s, while the genocide was still unfolding, the extermination with the destructive intent of the Jewish people was still ongoing. Jewish people, Roma and Sinti. We need also to understand that the Holocaust has been against anyone who, according to Hitler and the officials of the Third Reich, did not conform to the paradigm or the criteria of the pure race. So, of course, there were millions of Jews in Europe. So the Jewish people were the first and foremost target, but there were other minorities. There were, again, as I said, the Roma and Sinti. There were people with disabilities. There were people who were political opponents. And so, but again, of course, the massive the destruction that has been inflicted on the Jewish people as such is unspeakable and has made history. But this is just to say the destructive intent was broader than this group in particular. And back then, Raphael Lemkin, the scholar who coined the term genocide, and who has so much advocated for the adoption, for the drafting, who worked on the drafting and adopted for the adoption of the Genocide Convention. He had in mind, he knew and he articulated in his writings that genocide is, by its very etymology, destruction of a people, of a group of a people as such. And what does it mean as such? It means that it's the group targeted, the people targeted because of religious, ethnic, racial, national grounds. And there is no question for what concerns Palestine that the Palestinian constitute a group entitled to self-determination, meaning to exist free as a people in the land where they are, both in the form of a state. This is what has been recognized by international consensus in what remains of historical Palestine, meaning the Gaza Strip, the West Bank, and East Jerusalem, and as full citizens, full minorities, as Palestinians with Israeli citizenship. So they are recognized as a group. The fact that they are not respected as a group, they are targeted as a group. And I will return to this in a moment. But back to Lemkin. So Lemkin had in his writing, in his scholarship, considered the experience of colonized people during colonialism, and particularly settler colonialism. In these writings, settler colonialism appears quintessentially genocidal, and Lemkin described different modalities and different stages from what we would call today ethnic cleansing, forcible displacement, or forced sterilization, or mass killing, mass arbitrary detention. So all these practices, when directed massively against a group, against the people, were seen as elements that lead up in a sort of escalation to the commission of genocide. Genocide is a trajectory. It's a process, it's never an act. And what Lemkin was writing 90 years ago is proven true today, I mean, or in recent past, and it has proven true in the case of Myanmar, and it's proven true in the case of Palestine. But so Lemkin had an idea of genocide in mind, which comprised also the destruction of a people politically, culturally. These elements were not captured by the Genocide Convention, which Chris evoked and showed in his slide, only refers to given acts against a group of people identified not politically, but again, ethnicity, race, religious, or nationality. The cultural, and also if you look at the acts that are listed in the convention, acts of killing, subtraction of children, or infliction of physical or mental harm, the creation of conditions of life that would lead to the destruction of a people, of a group. These have a physical element. So the kind of cultural genocide, that erasure of culture, erasure of identity, that Lemkin had clear in mind, this was not taken into account. And why so? Because this is a product of the time when the Genocide Convention was ratified. Back then, the majority of member states we have today in the General Assembly were still under colonial yoke, and so the international community looked very much like the settler colonial bloc, with other few states who had reached independence and recognized the status at the international level. However, while cultural genocide and destruction of elements of national identity is not recognized as constituting an act of genocide, the jurisprudence has referred to it as circumstantial elements that need to be taken into account. And let me say something that will resonate strongly with any indigenous people in the call, and with anyone. I mean, it tends to resonate less with Westerners, but for an indigenous people, the land is not the place, as been said by a indigenous scholar. The land is not the place where you live. The land is who you are. Therefore, interrupting, breaking that connection with the land is to be seen as a destructive element. So while Lemkin was saying settler colonialism is genocidal in and of itself, Of course, the kind of jurisprudence that has developed could not capture it, because we have not had until now a settler colonial genocide to ever be litigated before an international court, because Rwanda was not one of those cases. Yes, we can argue that there was a colonial legacy for sure. I think that we still need to unpack the colonial legacy on on African political system and societal well-being, or the legacy of slavery. This is what we should be talking about, as in order to fight the colonial amnesia that doesn't allow us today to see what's happening in Palestine. But let's go back to the settler colonial. This is the first settler colonial genocide which will be litigated before an international tribunal. Of course, Bosnia, as I said, Rwanda could not display those features, or did not display those features, and so Bosnia Herzegovina or Croatia, what happened in Croatia, what happened in former Yugoslavia. But let's go back to the land. Understanding the land and the goal of erasing Palestinian presence from the land is fundamental to understand what's happening, what has happened as of October 7 in Palestine. So, zooming in Palestine, many scholars have argued, not lawyers, but like anthropologists or historians have argued that a genocide was already ongoing in Palestine at the hand of the subsequent Israeli governments, the Israeli state. And why so? Because they were looking precisely in a historical trajectory how the creation of the state of Israel and the project to create a state only for the Jews, because this is what we're talking about, the impact that it has had on the Palestinians as a people. It has fragmented them, segregated them, dispossessed them, resulted into mass killing and mass arbitrary detention. What I'm saying is not slogans, it's documented. I've written my second report on carcerality, describing the mass incarceration governance, meaning the legal system that is set up to persecute the Palestinians and lead them to defeat through preventive incarceration. And I'm so glad to have an Australian human rights lawyer who works with indigenous communities in Australia with me on the team, because she was saying, even now in Australia, in certain states, and again, this is not my area of expertise, but I'm speaking to an Australian audience. She was saying in certain states, even now, the majority of incarcerated people, including children, are Aboriginal. There is a link because it's not that these people have a natural propensity to commit crime. And listen to me, because this is also a realization I reached these days as I was unpacking what is genocide in Palestine. But it's so connected to right of self-determination, meaning allowing people to determine themselves the way they want, not imposing the laws that we, like settler colonial societies, have elaborated and then, or have concocted, and then they apply to them, so asking to conform. And if they do not, they fall into the cracks of the system. In Palestine, this is even more brutal, because if you read my second report, you see that Palestinians have been presumed guilty before any charge or judgment, before even any act. You end up in jail as a Palestinian if you possess materials that the army considers hostile, up to 10 years in jail. You can get imprisoned up to 10 years if you are part of a gathering where 10 or more people talk about political issues without the authorization of the army. And hey, it can be a political gathering, it can be a rally, but it can be a wedding, it can be a funeral. And these are, you remember Shirin Abu Akleh, the way the the pallbearers were attacked, this was an unauthorized political gathering for the Israelis, and this is why they could go on to the Palestinians with such ferocity and brutal force, because the Palestinians were violating the law, because they were gathering without authorization of the army. And also, you can be arrested up to 10 years if, for example, you are found in an area that the army has declared closed, in occupied land where Palestinians live. South Hebron Hills, I don't know if you've ever heard about this area, but this is slated for mass annexation. And there are 1,200 people living in an area that for 20 years has received no authorization to build any civilian building, any schools, any water pipe or whatever. So whatever the Palestinians would build, it would get destroyed. Now, any normal, any human being would have left those impossible living conditions. The Palestinians have stayed in that land and even lived in the rubbles of their once homes or in caves, but they have not left the land, because again, for an indigenous people, the land is who they are. And so the trees, and so anything that the land gives. There is such a huge, I wish you all had an experience in Palestine, because as you would see commonalities in, although the culture is very different, but with practices that I've heard of in Australia, common to Aboriginal people. This is so touching. It was so touching to me. So Israel wants the land for the Jews only. As Chris has said, for the Rakhine state, also in Israel has passed a law, the nation state law in 2018, which recognizes the self-determination, the right to self-determination for the Jews and the Jews only, from the river to the sea. So it includes what they call Judea and Samaria, meaning the West Bank. It doesn't mention Gaza, but again, it doesn't recognize any rights to the Palestinians who are indigenous to the land, not only in the state of Israel, but also the occupied Palestinian territory, where Israel has maintained an occupation for 57 years, as I said, where physical segregation in communities or arbitrary arrest and detention were means to enforce to prevent the growth of the people. So you can see when I say the trajectory, I'm not claiming that acts of genocide have been yet. I'm not claiming yet that acts of genocide have been committed before October 7th. But what I'm trying to say is that the situation was already horrible for the Palestinians as it was. October 7th happened. And after a few hours, here or weeks, here are the statements that get issued. President Isaac Herzog states that it's an entire nation out there responsible for October 7th, and Israel would break their backbone. Benjamin Netanyahu referred to Palestinians as Amalek and monsters. Amalek is a biblical term, and if you read what the exhortation Amalek means, you get shocked, because you will wonder, as I've done, not being a very religious person, and say, is it possible that the Bible contains this very violent language? And yes, it does. It's and it says, go destroy the Amalek, the mother, the suckling, the camel, and the donkey, anything. In a given context, a religious context like Israel, and especially in a mood when the society, where the people were in a revenge mood for what they had suffered on October 7th, which was very unprecedented, and it was horrible, no question about that. Crimes have been committed against Israeli civilians, and this is why the Commission of Inquiry and myself have advocated for the application of justice, investigation, and prosecution. Another path has been chosen instead. But the reference to a biblical passage in what in which God commands extermination has been extremely, extremely dangerous. And then I will get back to it because it has been executed on the ground by soldiers who have referred to Amalek in destroying homes, neighborhoods, in desecrating religious and intimate spaces of the Palestinians. And again, this has been the morale. Now, remember the language, cut the tall trees. This was the language that were used in the Rwandan genocide to inflate the souls against the Tutsi. But however, other statements that were issued, like Yoav Gallant, Minister of Defense, referred to the Palestinians as human animals, declared the full offense in Gaza, ordered to release all the restraints, and said that Gaza would never return to what it was. There are hundreds and hundreds of statements. I encourage everyone to look at the compilation made by the South African legal team to the ICJ, and also to the Security Council. They provided an updated annex with these statements. But what's important is I've documented acts of killing, acts of infliction of severe and bodily harm, the destruction of life in Gaza. All civilian infrastructure has been either destroyed or severely damaged. There are 90% of people who have been forcibly displaced, many of them up to 10 times since October 7. There was an order of evacuation imposed on the entire northern Gaza, which was home to 1,100,000 people, to flee from north to south, while the south was also being bombed, because during the first 3 months, 40% of the casualties occurred in areas that had been identified not as targets, as safe. And now, of the 400,000 people who remain in the north, as we speak, we see that Israel, after starving, bombing them for months, now it's going home. Israeli soldiers are going home by home, carrying out massacres. And again, someone has spoken of a genocide within a genocide. But yeah, this is what a genocide is: destruction of a people, of a group as a whole. There is no distinction between older, elderly, or young. There is no distinction between civilian and combatant. Every Palestinian is seen as a security threat. And why Israel is doing that? Because of the land. Greater Israel is the larger plan behind it, against which each declaration needs to be seen. I understand that some people would say, well, this is ethnic cleansing as it was established in Serbia, because in Bosnia versus Serbia, one of the cases that the court considered was the fact that the Serbs had ordered the forcible displacement or the ethnic cleansing of huge area of what was declared are the Srpska Republic within Bosnia. So an area which would confederate the areas where the majority of Serbs were, pushing into other areas of Bosnia, the local Bosnians. In that case, the court considered that there was no genocide, it was ethnic cleansing. While even if I take this argument as a matter of fact, I won't get into this, although I think that it's problematic from a human rights point of view not to consider how harmful to the people as a whole is such violent uprooting. But this is what the court has established. In the case of Palestine, it's different, because Palestinians, this is the land they have. If they are kicked out of that, they have no other place where to go. And this is why breaking this bond is genocidal in itself. It's the full erasure. And as William Shabazz tells us, in order to establish whether genocidal intent, as Chris said, is a crime in itself. I mean, genocidal incitement, but it's different from genocide. how do we see the passage from incitement to the crime, the commission of the crime itself? We need to look at various elements, at the opportunity, at the reality, at the capacity. Did Israel have the capacity to commit genocide? Yes, it did. Had the opportunity to commit genocide? Yes, it did. And it seized the opportunity to do that after October 7. And the motives are not relevant, whether they have done it to save, whether some has done it to save themselves and stay in politics, or to liberate the hostages, or these are motives. This has nothing to do with intent. Intent is the mindset to destroy. Whatever might have ignited it is the intent to destroy a people. And two more elements before I conclude. It's this intent has been, again, proclaimed, executed, but not just against the Palestinians in the Gaza Strip. Because as of October 7, extrajudicial killings in the West Bank have accelerated. And so there are over 700 people who have been killed in the past 12 months, 170 of whom, according to the latest statistics and count, were children. And like in Gaza, many of the children are killed and found with bullets in their chest and head. So there is a shoot to kill policy, as it was already demonstrated prior to October. But also think of two other elements, arrest and detention. While almost 4,000 people have been arrested in Gaza, reported arrested, we don't know how many in reality from Gaza have been taken by the army, because the figures are fluctuating and are not confirmed. But there might be many more, because many more are missing. And then over 9,000 people have been detained from the West Bank and East Jerusalem. And the same harsh conditions, which have been described as widespread and systematic abuse, including torture by Israeli lawyers and Israeli human rights organizations, this has been inflicted against any Palestinians. Why? Because it was an entire nation responsible. They were the Amalek, and they had to be disgraced and destroyed. And this has not only happened to the body of the Palestinians, this has happened to the space. Because as of October 7, the attacks against the civilian infrastructure in the West Bank and East Jerusalem, so as the annexation, so as the forcible displacement, have escalated dramatically, up to the point that from July, August this year, there were renewed aerial bombardment targeting hospitals, targeting essential infrastructure, destroying homes and neighborhoods, because the Palestinians had to be forcibly displaced. So if we fail to see the indestructible intent in this one, we will have not only missed the forest for the trees, but also proven once again that as a collective, as an international community, we are unable to see not only genocide, but genocidal responsibility, because Israeli leaders have said and done it. And the last element, this is not like a war-torn former Yugoslavia. This is not, Israel has at least a claimed rule of law system. This cannot be identified as the action of some genocidal leaders only. Because while I'm absolutely sure that there are a number of people in the Israeli government who should be investigated and prosecuted for genocide as we speak, what are the checks and balances that work in a system? What did the other cabinet ministers did? What did the parliament do? What did the judiciary do when it was also ordered to investigate and prosecute incitement to commit acts of genocide? So if we don't see the state responsibility behind this genocide, again, we will have failed, we will have continued to fail the last indigenous people that risk to be finally eradicated and uprooted at the end of a genocidal project, settler colonial project. Thank you so much. I hope I have the feeling that I took too much.
Thank you very much, Francesca, I'm sorry that time is limited, and I appreciate both the information that you provided us all with, and the process of education that I think we all need to go through. And this is an opportunity for discussion. So I am very sorry the time is limited. We've had a number of questions on the chat, and so maybe we can extend if people can stay a bit longer. We started a bit late, so maybe we can go a bit over time, perhaps for another 15 minutes before I ask my colleague from Start Atem to close this webinar. So the floor is open for questions to either both of the speakers, and so please, either you can post questions in the chat, or you can put your hand up with the either physically, but preferably through those little emoticons in the Zoom. If you raise your hand, we'll try and see it and try and come to you in the time that we have. I will begin perhaps by conveying some of the questions that we've received already from people on the chat. So there is a specific one, I think, for you, Chris, which is around the 1982 citizenship law in Myanmar, and whether that constitutes an act under the convention. There is a more general question, perhaps for both you, Francesca, and also Chris, around ethnic cleansing and genocide. What is the distinction between the two? And a third question that came, maybe you'd like to deal with in the same context, because it's partly a definitional issue, is how does genocide and gender, can genocide be applied to gender? And maybe that goes back to the historical context in which the convention was drafted, but maybe the jurisprudence issues bear on that. Other questions that have come in bear on accountability, which maybe we can go to in a second round. But for those first ones, the specific one on Myanmar, differences between ethnic cleansing and genocide, and how gender relates to the acts of genocide and definitions, jurisprudence. Thank you.
Should I go first, Patrick, and just be as quick as I can be? The 1982 Citizenship Act, I would say, is evidence rather than a crime in itself. It certainly adds to the evidence of genocide against the Rohingya. It certainly adds to evidence of persecution, which is a crime against humanity, relating to all of the ethnic groups in Myanmar. So it has particular relevance as part of the case under both genocide and under crimes against humanity. And I would put it in that category rather than trying to treat it in isolation. It's part of the whole system in Myanmar. The difference between ethnic cleansing and genocide is the purpose. Ethnic cleansing is not associated with the purpose of destroying a protected group in whole or in part. I should say too that ethnic cleansing is not actually a term under international law. It's a popular term, a summary of perhaps what could be called forcible deportation, which is the actual crime that is being looked at in the International Criminal Court in relation to the Rohingya. But to use the popular expression ethnic cleansing and contrast it with genocide, I would say that the key difference is the genocidal intent to destroy the protected group in whole or in part. So they're the two that I can deal with, and leave the third to Francesca.
No, just yeah. I mean, I would like to add to what Chris said regarding ethnic cleansing. The element of destruction that can be extermination, but the destruction is not there. There is the removal. Then we can argue that the removal is also destructive, but it's not qualified as such. And the cleansing is not a crime. It can include crimes, and it's a policy that might, in fact, include acts of genocide. This is what was concluded in 1993, I believe, by a UN commission which was mandated to study the ethnic cleansing. Sorry, I thought that the other question was addressed to you, Chris. Can you or Patrick quickly remind me of it?
I think the other question was really around the issue of gender. It wasn't one of the categories
Yeah,
in relation.
Sorry. Yeah.
Thanks.
Look, there is a. I'm not a genocide scholar. In fact, I mean, I've become a genocide chronicler reluctantly. But I personally don't know. I cannot answer this question. But of course, there is an element of gender as I think of the genocidal act, because the prevention of birth is something that we can see. This is not an act of genocide that unfortunately I've had the opportunity to study, but definitely it should, because the destruction of the fertility clinics and the prevention of prenatal birth, the prevention of women accessing the care that would also allow to preserve the health necessary to give birth, it's something that needs to be studied on its own. So yes, I think that there is a possibility to study the genocide, the gender dimension of genocide, including in the case of Palestine, but this is not where my expertise is, I'm sorry.
Okay. Thank you very much, Francesca and Chris, for those elaborations. We've had a lot of chat and contributions around the challenge of accountability. We've also had, I think, a number of different situations raised, including in relation to North Korea and Kim Jong-un, and why isn't that a case, I think, in the ICC so far. But I think the general sense is we're discussing these very urgent matters while they're going on, while the violations are continuing. Can either of you elaborate in terms of, I think you must both be very, very frustrated also at the lack of accountability, but the utility of these tools, can you speak to them and how people might be able to use these tools in their advocacy more? And then I'll come back to a couple of the specific questions that have come in, but I'm generalizing some of the frustrations, I think, about the failure to apply the international laws that exist and the weakness of the mechanisms of accountability that currently exist. And I think your reflections as people who've worked with these systems, who know the law so well, would be very valuable for people to hear.
Chris, would you like to go first, or shall I go with my thoughts and frustration? I think, like everyone, and also the person who asked this question, clearly there is some anxiety regarding the lack of accountability. Now, I do believe that, and I think I dealt with it also in the last report, which will become public in the coming days. It's called "The Genocide as Colonial Erasure." There is an element of impunity that has become so structural in Israel. Many states, actually, I don't think that there is any state who doesn't violate at some point certain parts of international law. So it's not about singling out Israel. What is characteristic of Israel is the fact that since the very establishment, it has violated systematically international law, including UN resolutions by the General Assembly, Security Council, and Human Rights Council, and decisions of the International Court of Justice. This creates a situation where impunity has been part of the modus operandi of Israel as a state. So there has been, this is just to say, the lack of accountability for Israel comes from afar. Even today, when we know that Israel must end its occupation and withdraw all the colonies and stop trying to annex Palestinian territory, in the face of this, there is a general lack of accountability. And before talking of the courts, let me say, the first form of accountability happens with law enforcement, and at the international level, it's not entirely accurate to say that there is no law enforcement. Member states are the enforcer, and it's not that they don't take on this responsibility. They do take on this responsibility when there is political will and political convenience. And this is not the case with Israel, because Israel has benefited and profited from the political cover given, particularly by the Western group, which includes Australia. So no one really acts to enforce international law in the forms of sanction, forms of divestment, which again is not an act of charity, or a moral obligation. This is a legal obligation for Australia today to stop trading both weapons, military strategy, and goods. Is fundamental for Australian universities today to suspend any forms of partnership with Israeli universities who might be part of the illegal occupation, as Israeli scholar Maya Wind has wonderfully elaborated. This is fundamental. Again, this is the first form of accountability. Then, of course, there is international justice. Both the Court of Justice, which is, of course, it's taking time to determine if Israel has committed genocide, because it's also dealing with the case of Myanmar at the same time. And the International Criminal Court. I mean, I do personally believe that the violations that have occurred in Israel and Palestine will require an ad hoc tribunal. And this is not in order to argue against the authority of the ICC, but the ICC will be engulfed by all the crimes, is engulfed, in fact, by all the crimes that we'll have to deal with. And if it doesn't, it will betray justice. So I personally think that there is no opportunity whatsoever that the ICC on its own will deliver justice. And another element, are we sure that retributive justice is going to be such a solace for the victims? Is it? Surely at the high level, yes. I do believe that the architect of these illegal endeavors, and so the responsible of the crimes committed both on October 7, prior to October 7 and after, should be ensured to justice. Well, Israel has already taken care of two of those who had conducted the assaults against Israel on October 7. But the thing is that the retributive justice, while it is to be pursued, needs to be accompanied by other forms of justice, that in the forms of reparation. And the other element I wanted to add is that while the ICC has a huge responsibility, and it's unacceptable that the court has not confirmed the arrest warrants, because these crimes, the evidence of these crimes, it's so all over. But there are domestic courts in countries that have universal jurisdictions, meaning countries that can investigate war crimes and crimes against humanity. And then genocide is universal jurisdiction. Genocide, all the states who have ratified the Genocide Convention, which is customary international law, have an obligation to investigate and prosecute the crimes of genocide. But also think of all the nationals, including of your country, who might have committed crimes by fighting in the Israeli army or are settlers. This is a reality. So I truly hope this is a call to activists to try to strategize on how to activate strategic litigation, but also how to amplify the need for what the BDS movement is asking, in fact. Application of sanctions and diplomatic, political, economic measures to Israel as long as it remains an unlawful occupier and a state that commits crimes against the Palestinians.
Thank you very much, Francesca. Chris, did you want to add?
Look, just a very general statement, I have to say, a very general statement. Over the last 80 years, a very good body of international law has been developed. There is law, and it's good law. We have started over the last 20 years to develop good judicial institutions. The International Criminal Court is only 20 years old. The International Court of Justice is older, but it's doing more work now than it's ever done. So we have law, we have a framework for enforcement, but we do not have the means of enforcement. This, after 80 years, is still where the downfall is. And it's mostly because of the political issues that Francesca has talked about. States are looked to for enforcement, but they don't do it. And they don't do it for political reasons. So even though we hear talk, particularly from Western governments, about the international rule of law, there is no international rule of law. There's international law, there's international courts, but there is no international rule of law. And as many leading international lawyers and other international officials have said recently, there is a crisis in international law and the international system that could well see the collapse of everything that has been built over the last 80 years. And that is a crisis that is generated by hypocrisy. We will never have the rule of law until we have consistency, until we have law taking precedence over politics, and until we have no more hypocrisy. How can we praise the International Court of Justice for its decision on the Ukraine against Russia genocide case and condemn it for taking a case of South Africa against Israel on genocide? How can we praise the International Criminal Court for issuing warrants against Putin and threaten it with sanctions if they issue warrants against Netanyahu? How can we demand that China observe the decision of the International Tribunal on the Law of the Sea in relation to the South China Sea, while undermining the work of the International Court of Justice and the International Criminal Court? The whole system, it can honestly be said, is on the brink of collapse. And it will collapse unless we end the hypocrisy and apply the law consistently.
Thank you very much, Chris. I think that brings us, in a way, to a very sobering, I'm not sure so hopeful conclusion to this discussion, but it comes back to the purpose that we have for these series of webinars, which is really to try and build understanding of the law and of the mechanisms, to look at how advocates can use them effectively in their engagement. And our understanding in the diplomacy training program that the implementation of international human rights standards rests more than ever on the political will that can be generated through effective advocacy. And so with that, I would like to thank deeply Chris and Francesca for their participation today when both are extraordinarily busy, but more importantly for the extraordinary work that they do. And I wish more power to both of you in that work. And we hope that you might be willing to rejoin these conversations and these discussions. As we said at the beginning, this is the first of a series of webinars that the Diplomacy Training Program is organising with the Service for the Treatment and Rehabilitation of Torture and Trauma Survivors. And I will pass over now to my colleague, Dr. Atem from STARTS, to say a formal word of thank you and acknowledgement to you all. Thank you to all the participants here, though, and it's been lovely to see so many alumni of the DTP programs, and we look forward to seeing you again. Thank you.
Thank you, Patrick. And I would like to acknowledge the traditional custodians of the lands from which I'm zooming in from. And this is Sydney, southwestern Sydney, the land of the Gadigal people. And I would like to acknowledge their custodians, elders, who are the custodians of the land, and also acknowledge other people who are zooming in from, places where there are traditional custodians as well, and Indigenous people. Look, thank you very much, Francesca and Chris. This is a very important work that you are doing. As Patrick said, the aim of this webinar in a series, there'll be a few more, and we are hoping you will be joining us to talk more about these issues, is to build capacity of the groups that we work with at STARTS, and the capacity of communities that are interested. Many of the people we work with have suffered some of the atrocities that you are talking about and you are thinking deeply about. There is a lot that is happening, and I can identify with some of the things you have said. I come from a background also of, I don't know whether that is genocide, I can say because I'm not a lawyer, but I come from South Sudan and there has been war. And that is why I came to Australia. So when these things are happening and I hear the news and the conversation about these things, they are very triggering to me personally because of my personal experience. But they are very important conversations. The thing is, I think there is hope, and the hope is that there are human beings involved in this, and the human being involved in this can be traumatized, can be killed, but the human spirit remains. And that is my hope, that doing these webinars is building the capacity of those human beings who are not hurt, who do not have the capacity sometimes, but those human beings are here, and they are still there. And having forums like this and having you coming with your expertise and explaining to us the law, international law, and the ways that people who may have not been able to do advocacy or do something about it can begin to think about, these situations. What can we do? How can we respond? And we can only respond by understanding what is happening. Politics is about all of us, and each of us here has a voice in the political process. I am an Australian citizen. I have influence on the Australian government. They are doing things on my behalf. I have the vote, so I should be able to use my vote to tell the Australian government, things are not going all right. You shouldn't be doing this because you are doing these things on my behalf. And so from the perspective of STARS doesn't take any sides. Our concern is human suffering, regardless of who is on the wrong or what the politics is. It's about human suffering. It's about the impact of organized violence and how that generates, trauma. And our role is trying to heal that trauma, regardless of who is perpetrating it. And so it's very sad for us to actually exist as an organization, because it's the suffering and the impact of violence, organized violence, state terrorism, that makes us exist, and we would like to not exist. But the reality is we do exist, and we try to support people. So thank you very much again, and thank you everybody for attending this webinar. Apologies for the start, it was a bit rocky, but thank you very much for bearing with us and for being here. I'll get back to you, Patrick, to close.
I think I can add nothing more, Atem. That's we're obviously very privileged to work with STARTS, you and your team, and we look forward to the work. We look forward to seeing many of you again. I'm very sorry if we didn't get to your questions and your issues, but perhaps we can pick those up in the next one. And we welcome your feedback about the webinar, anything that's come up here. We will share the resources and the links after the webinar with all those who have registered. And yes, good luck, go well, take care. Thanks very much, all of you. Bye now.
Thank you so much. Bye-bye.
Thank you. Bye-bye, Patrick.
Thank you. Bye-bye from Uganda.
Thank you. Bye-bye from Timor-Leste.
Bye.